We're gonna stay there. You put.
Yeah, go this way, right? Are you ready? Good afternoon. Welcome. On behalf of Venable and the Employee Benefits and Executive Compensation Group, we're glad that you could join us for today's luncheon and webinar. Venable is a firm with more than 600 attorneys in 9 offices, coast to coast, and we have a wide practice of corporate and business law, litigation, intellectual property, privacy and security, and regulatory and governmental affairs. Today's webinar is being recorded, so everyone knows that. And another housekeeping item is with respect to questions. As each speaker goes through the program, we can take a few questions, but we really have a lot of content to cover today. If we don't get to your question, what we're going to do is have index cards handed out, and we'll figure out how to get back to you next week with responses to any questions that we don't get answered today. For the webinar attendees, you can use the box on the webinar page to ask any question. I'm Lisa Tavares, and I'm your moderator for today, and I want to introduce my colleagues. To my right, in order, is Tora Johnson, Harry Atlas, Chris Condalucci, and Todd Horn. Today's agenda, as I mentioned, is pretty full. We're going to discuss a variety of topics related to the employer mandate, starting with player pay rules, identifying full-time employees, affordability and minimum value standards, reporting obligations, interacting with the exchanges, litigation risk, and next steps. I'd like to start with an introduction to the play or pay rules. As I mentioned, we have a lot to cover today. We decided the most important thing to do was to focus on the employer mandate. We know there are a lot of questions related to the Affordable Care Act in general. We're not going to talk specifically today about the new fees on health plans or the Cadillac tax or other issues. We're going to focus on play or pay and the interaction with the exchanges in anticipation of the effective date of the law in 2015. So let's get started by talking about 2 of the mandates. First, the individual mandate. Hold on. The individual mandate that was effective January 1st, 2014, was put into law under the Patient Protection and Affordable Care Act, and it requires individuals to maintain minimum essential coverage or to pay a penalty tax. Individuals that qualify for a premium subsidy are able to go to the exchange and purchase coverage if you meet certain requirements. Next is the employer mandate. So the big question is, when is the employer mandate effective? The effective date is now January 1, 2015. That's after a 1-year delay of the original effective date of January 1, 2014. We would note that there's a special rule for fiscal year plans. It's possible that a fiscal year plan may have a further delayed effective date to the first day of their 2015 plan year. But there's some complicated rules, and we'd encourage you to talk further with one of us if you're in the situation that you have a fiscal year plan and you want to determine whether or not you're actually eligible for that relief. The Affordable Care Act imposes a mandate on large employers requiring them to provide minimum essential coverage to their full-time employees and their dependent children up to age 26, so not spouses, dependent children, or for the employer to pay a penalty tax. In addition to minimum essential coverage, the coverage must be affordable and must provide minimum value, or else the employer, again, is subject to a penalty tax. So there are 2 tests to consider: the minimum essential coverage and then the affordability and minimum value test, which Tora is going to talk more specifically about what all of this means, some technical words, and what context to put it into. The employer mandate applies to applicable large employers. And the applicable large employer is defined as an employer that's employed an average of at least 50 full-time employees on business days during the preceding calendar year. So the 50 employees, you can't just say, oh, I have 50 employees or I don't, because the rule actually includes full-time equivalents. And that's another complicated process to determine who are those full-time equivalents. And so we'll delve more into that. Someone in the back had already asked a question about how this relates. The employer mandate applies on a control group basis. You may have special circumstances where we need to sit down and think about how the control group rules don't apply to you, particularly with respect to non-exempt tax employee or something, but we're happy to walk through those issues with you. A full-time employee is someone who works 30 hours a week or 130 hours a month. Employers should be using a common law test for identifying who are their employees. Here we note that there's a special transition rule for 2015. The 50 number becomes 100 full-time employees. That's your test. I was at a meeting of tax lawyers the other day where one of the government representatives said that 100 is the new 50. So I thought that was a cute way to try to remember what the rule is. While that may not really be a big issue for a lot of us in this room because your entities have far more employees, that's a rule that the government put in place to help with the transition to what's really a sea change in the law for all employers. Next, we're going to talk about the trigger for the penalty tax. A penalty tax is due for any month in which at least one full-time employee is certified to the employer as having gone out to the exchange, received coverage, and received a premium subsidy from the government. So the test isn't that they went out to the exchange ultimately, it's whether or not they received the premium subsidy. An individual is not eligible, though, for the premium subsidy if they've otherwise been offered employer group health coverage that would be minimum essential coverage, but if it's affordable, a minimum value. So we'll talk later about how, when we talk about the interactions with the exchanges, how you may run into inquiries about that information, whether or not you've provided what's required. At this point, I'm going to turn it over to Tora to talk about the mechanics of the penalty.
Thank you, Lisa. So yes, my task before me today is to walk you through all the glorious detail of the player pay penalties. And it's a vocabulary in and of itself, and I want to strike the right balance of letting you know how these rules work, but without causing you to go running from the room. So I will use the eyes and faces of the folks in the audience as my gauge for that. And I apologize because it is a little bit of a daunting task. So the first penalty I will refer to as the no coverage penalty. It's also referred to as the A penalty because it's located in subsection A of 4980H of the Internal Revenue Code. But the regulators will even tell you that the A subsection is appropriate because this is the awful penalty. I will be talking about a second penalty, which is in subsection B, and it's not quite as awful. So when do you trigger this A penalty, no coverage penalty? It's triggered if a large employer, again over 100 employees including part-timers in 2015, drops down to 50 in 2016. It's triggered if a large employer fails to offer coverage to more than 5% of its full-time employees, and one of those full-time employees goes out to an exchange, obtains coverage, and obtains a premium from the government to pay for that coverage. So let me just spend a little time on this for a moment. It is only a requirement that coverage be offered. The employer has no responsibility as to whether or not the employee actually takes the coverage. It needs to be offered to the employee who's a full-time employee, which is 30 hours or more a week, and we'll talk about how you measure that in a moment. And the coverage needs to include coverage for the employee's dependent children up through age 26. No requirement to offer spousal coverage. And again, failing to offer the coverage isn't enough to trigger the penalty. You actually have to have a full-timer who goes to the exchange to get subsidized coverage. So who can get subsidized coverage? It's somebody who's making above the Medicaid eligibility amount, which can vary by state, and for an individual, it's household income of up to about $45,000, and for a family of 4, up to about $92,000. So there's broad eligibility for the government subsidy. And I see I already have a question in the back of the room.
When determining 5%, is that also on a control group basis?
No, I do not think so. So to count to 50, the question in the back of the room was when you look at that 5% margin of error, is that on a control group basis or corporation by corporation? And so when you're counting to see whether you're a large employer, that is on a control group basis, but when you look at the text of when you actually trigger the penalty, it's on corporation by corporation, and same with that 5%, which also reminds me to footnote that there's a very special transitional rule for 2015 where that margin of error is not just 5%, it's 30%. So in 2015, you have to get an offer of coverage out to at least 70% of your full-time employees. In 2016, that increases to 95%. So the government's really doing us a favor here in getting our policies and our procedures in place for 2015. We can test them out, see how good we are, and then they really change the playing field in 2016 and saying it's not just good enough to be good, you have to be great, you have to make sure you're 95% accurate in it. So how do you calculate the penalty? And frankly, I can't see the screen, so if I run behind, let me know.
We can look behind you.
Just to double check.
Okay.
We'll give you the high sign.
Thank you. So how do you calculate it? The penalty on an annual basis is $2,000 times your total number of full-time employees. That's the annual penalty. It's actually calculated month by month. And you do get a little bit of a break. You get to discount your first 30 full-timers in 2016 going forward. In 2015, you get to discount your first 80 full-time employees. That's not much. So just to put an example out there, if you have 1,000 full-time employees and you trigger this penalty, you're talking about roughly a $1.9 million penalty that's not deductible. So it's big dollars. And again, it is triggered on entity by entity within a control group or an affiliated service group of entities. And most important is you want to make sure, you have a choice. You can be compliant with the law and just decide, I'm going to pay the penalties and drop coverage. But what you don't want to find yourself to be in a position of is offering coverage and paying premiums or paying the benefits if you're self-insured for the majority of your employees and also inadvertently triggering this penalty. So if you're offering coverage to the majority of your employees, but you haven't reached that 70% threshold for 2015 or that 95% threshold for 2016, and you have an employee that goes to the exchange and gets the subsidy, you will be paying the penalty on even those full-time employees that you've extended coverage to.
And Tora, one footnote on the penalty, because I actually have had conversations recently with some clients about this, is the penalty is actually indexed, not to the normal consumer price index, CPI, that typically is the indexer under the Internal Revenue Code when it comes to different benefits or thresholds under the Internal Revenue Code. Instead, this particular penalty is indexed to the increase in premium over a 2013 benchmark. So when I give the example of in 2016, let's say the cost of premiums that the government will specify in a notice is 10% greater than the cost of coverage that the government specified in a similar notice in 2013, the penalty is indexed to 10% as opposed to something smaller. So there's a sizable index as compared to how penalties or other dollar thresholds under the code are indexed, which is something to keep in the back of your mind when it comes to, hey, I want to avoid this penalty. Hey, it's $2,000. Well, that seems really low. Well, over time, it's going to index at a pretty significant clip, so it's an important piece to know.
Thanks, Chris. So then the next question is, who are my full-time employees that I need to extend coverage to? This is the first time where the government has come in and said to employers, we have a benchmark as to who your full-time employees are for the offer of health coverage. And they set it at 30, which is and can, for some employers, be a little bit of a hardship. They're not used to setting it at 30. They're looking more at 35 or 40. So the government is saying it's 30 hours on average in a week, or 130 hours over a month. And so what do you need to count? You need to count each hour of service for which an employee is paid because of the work that he or she has performed, or for which he is due or she is due pay because of paid leave, vacation, jury duty, military duty, etc. So it's time in which they are eligible for pay either because of their work or it's a paid time off. So the government and the regulations have given us two methods for counting those hours of service. The first is the monthly measurement method, and the second is the look-back method. I'm going to start with the monthly measurement method, and in particular with ongoing employees. So these are employees that you've already hired and have been with you for a period of time. And this is retrospective. So you come to the end of May, it's June 1st, you look back and you say, gee, did I get an offer of coverage out for the month of May to at least 70% in 2015, 95% in 2016 of my full-time employees? So there's very little margin of error, and if you look back and you've made a mistake, you owe the penalty. There's no correction. That's with your ongoing. What do you do about new employees? Well, any new employee that you hire and you reasonably expect is going to work 30 hours or more on average during a week, you need to get an offer of coverage out. And you actually have a fair amount of time under the employer mandate to do that. You have until the first day of the first calendar month, immediately following 3 full months of employment. So in my example, you're hired June 15th. The employer has a stub period of June, all of July, August, and September to get an offer of coverage out by October 1st. But there's very false comfort in that because there's another provision under the Affordable Care Act that says if you are offering coverage, and we don't care whether it's full-time, part-time, if you're making an offer of coverage of health care, you need to allow that person in on the 91st day after they've hit all the eligibility requirements. So you really have to follow that 90-day rule. That's the easiest method. But again, if you're wrong, it's already too late. And so employers asked for another mechanism to count hours, and the government delivered the look-back measurement method. And we'll spend a few minutes at the end after I presented them both as to which is better for certain employers. But this look-back period says you have a measuring period, and you can look over a measurement period whether your employees average 30 hours or more a week. And then if they did, you have to offer them coverage for a correspondingly long period of time called a stability period. And in between the measuring period and the stability period, there's an administrative period where you look back and you say, did they have the 30 hours on average a week? And to get an offer of coverage out that's effective as of the first day of the stability period. There are some parameters about how long each of these periods can be. That's on the slide 15. I will tell you in the next slide what I think will work for the majority of employers, and this is assuming that you run on a calendar year. You're going to want, if you use this method, to have about a year standard measuring period, because that's the longest period of time permitted under the regulations to allow somebody's hours to even out, and it does the best for accounting for blips in people's hours. And you're going to want to run it so that it ends with your open enrollment period. So I'm thinking most employers are going to use November to October, or maybe a November 15th to October 14th of the following year as their measurement period. Then their administrative period, where they look back and see did people have the 30 hours or more, is going to dovetail with their open enrollment period, and they'll get their offers of coverage out. And then the stability period is going to be the calendar year. It's going to be the plan year, starting in January. But you will see that as soon as you finish one standard measurement period, you're going to start your next. And so in this example, your next measurement period is November of 2014 through the end of October of 2015 to determine whether or not you need to extend coverage until January 1 of 2016. And I think that in getting all of this information out to you, this is regarding the employees that you have today, what I was just talking about. The rules get a little bit more complicated when you get to new hires. So if you're using the look-back measurement period and you have a new hire and you know that they're going to average the 30 hours or more a week, then you need to get them out an offer of coverage. And it's the same rule that I just talked about as if you were using the monthly measurement, and really you have the concern of getting the offer of coverage out on the 91st day so that they can come in on the 91st day after they've been hired. But for everybody else, for folks that you hire and you don't know whether or not they're going to work 30 hours or more on average during a week, there's a new term of art called variable hour, and that's who those employees are. They are your part-timers that you don't know, you think will work less than 30 hours on average a week. They're also your seasonal employees, and seasonal employees are those that you think will be hired and working for you for less than 6 months, and their employment is tied to a season. It's your lifeguards, it's your ski instructors. You're allowed under this method to treat them as variable hour, even if you know they're going to work 30 hours or more. It's a special carve-out rule. Generally in this category is all your new hires and you're not sure whether or not they're going to work 30. The exception is seasonal. You can put into this category even though you know they're going to work more than 30. It's a special rule. So, and I've covered the content of this slide. This is essentially the fact that for those that you know are going to work the 30 hours, you need to get that offer of coverage out timely. Everybody else, all these other new hires, you can put into their own unique measuring period. And this is when you might start to want to run from the room, because what it really means is that for a first year of employment, employees have their own, new hires have their own unique measurement period and stability period. And that means if you hire 365 days a year, you could have 365 initial measuring periods. The best I can do is get you down to 12. What the rules allow you to do is push new hires in 1 month off to the first of the following month. So everybody hired in May, you start tracking their hours during this initial measuring period in June. And you look and see, so their stability period isn't necessarily going to line up with the plan year, and the administrative period you have to ascertain whether or not they were full-time during their initial measurement period, you don't quite have 90 days. In fact, for very complicated reasons, you're going to end up with about a month's worth of time to look back. But that's okay because this is just your new hire bucket of folks. And you need to also capture them in your next standard measurement period. So let's just take my new hire for a moment who came in, hired May 15th. You start measuring their hours. You know that they're not going to work the 30 hours. You think they're variable hour. You have good cause to think they're variable. So you don't offer them coverage. You put them in this test. You look at their hours for their own unique year measuring period. And you see during the administrative period they tested full time. So then you need to offer them an offer of coverage for a year's time, but then you need to collect their hours with your standard measurement period that begins either that November 1st or that October 15th. And you can't shortchange them. So if during their initial measuring period they test full time and you extend an offer of coverage for a year, and then you capture them in the standard measurement period, and in that case they don't test full time, you still need to offer them that coverage for the entire year of their initial stability period, even though it means that you're going to cut off their coverage in that light blue box in the middle of your plan year. And then there are a few other nuances to the use of the look-back measurement period. Essentially, the general rule is if you have somebody during a stability period that has a drastic change in hours, and let's for this case say that they have a reduction in hours, they're in a stability period, so you can't take away their eligibility like you might today, but their drop in hours is going to be reflected in whatever measurement period that they are in and will impact whether or not they are full-time for the next stability period and whether you need to extend them coverage. There are also special rules for folks who are out on protected leave, such as unpaid FMLA leave. You can't just put in zeros and adversely impact their eligibility for the next stability period. There are special rules to account for protected leave so that they're not adversely impacted. And then there are rules about rehires. So what if you had somebody who tested full-time and was offered coverage during the stability period and took you up on your offer and then was terminated and then rehired? Do you have to put them back in the plan, or can you say, you know what, you're a new hire and I'm going to subject you to the testing regime because I don't know if you're going to work the 30 hours. Depends on how long they've been out. If they've been out less than 13 weeks, then they get reinstated as full-time and that offer of coverage needs to be offered again to them. If they've been gone for more than 13 weeks, then you can treat them as a new hire, and you can, if you don't know that they're going to work the 30 hours, you can put them in a testing regime and not offer coverage. And now I'm going to skip ahead.
I was just going to say, what's interesting about the break in service rules is initially under the proposed regulations, the break was 26 weeks. When the Treasury Department finalized those rules, they slimmed it down to 13 weeks break in service. However, if you are an educational organization, the 26 weeks break in service rules still apply. So it's important to know that if you're an educational organization, it's a 26-week break in service versus the 13 weeks, which is the general rule that are in the final regulations.
That's right. So now, who might want to use which of these methods? I've actually skipped ahead to slide 22. The monthly measurement method is the simplest. It doesn't have all these nuances, but it only works well for employers that know they have a steady workforce. So if you know you just have full-timers and you define that as folks working the 30 hours, then this is a great model for you. Or if even if not everybody is full-time, but hours are steady, so your real part-timers are only ever going to work 20 hours or less, then you could have some comfort in using the monthly measurement. Remembering you have 2015 to play with it because you have a larger margin of error. Now, you also might want to consider, and some employers are considering, offering a very minimum benefit, called a skinny plan or a basic plan, to all employees to avoid this A penalty, this awful penalty. The A penalty, unlike the B penalty, really doesn't have a lot of bells and whistles is what needs to be offered. So some employers are saying, I'm just going to get an offer of very basic coverage out to everybody, knowing that I've protected myself from the A penalty. And then if you're doing that, the monthly measurement might make sense. If, on the other hand, you don't want to offer coverage to everybody, and you have a large portion of your population that's on call, per diem, shift, or seasonal, your best option is to use the look-back measurement method so that you don't need to offer them coverage when they're hired, and you can see whether or not they, quote-unquote, earned coverage for the next stability period. And then going back to, hopefully, slide 21, the government is telling you and is very prescriptive about what type of employees or your ability to use different measurement methods for different types of employees. So these are the only categories on the slide for which you can differentiate whether you're using a look-back or monthly measurement. So for example, you could decide that your hourlies are perfect for the look-back measurement method, but your salaried are going to be on the monthly measurement. What you cannot do is then within your salary decide that for your predictable folks you're going to use the monthly measurement, and for your unpredictable folks you're going to use your look-back measurement period. They're on to that game. They said that's too much discretion in the hands of the employer. So that is a very much of a whirlwind of that awful A penalty. The unaffordability penalty, and my time is running short, is much simpler in comparison, but it is a lurking penalty. It springs up under these regulations in places where you do not look and expect it. It is triggered if the coverage that you offer your employees for employee-only coverage under your base option, if their premium is more than 9.5% of their household income, or the health plan coverage isn't rich enough. So that first trigger looks at, if you have three options, you're going to look at your least expensive option, you're going to look at what your premium you charge the individual for that option. Doesn't matter what you charge on the spousal coverage, doesn't matter what you charge on the dependent children coverage. And you say, okay, is that more than 9.5% of their household income? It can also be triggered, even if it's less than the 9.5%, it's triggered if the plan isn't rich enough, doesn't provide enough benefits, and I'll talk about that in just a second. So to trigger it, though, it's just like the A penalty. You actually have to have an employee that is full-time that goes to an exchange and gets subsidized coverage on the exchange. But there's no multiplier. It's just on that individual who's a full-timer who gets that subsidized coverage. And again, it's the same eligibility requirements. You're making up to $45,000 as an individual, up to about $92,000 as a family of 4. And it's $3,000 a year, but just again on that one individual. So an employer has no idea what a household income is. So the government has given you some safe harbors. One is you can use the employee's W-2 from the employer. That is not predictive. That's really at the end of the year. It might work fine for salaried where it's steady income. Not great for hourly workers, shift workers, etc. So you can use a rate of pay, which for hourly workers is the formula. You use 9.5% times their rate of pay times 130 hours a month, regardless of how many hours they actually end up working. So it's a little bit more of a predictor. Or you can use 9.5% of the federal poverty limit, which means you're looking at an annual premium of about $1,100, which is hard for most employers to reach, although some employers have high deductible health plans where they offer individual-only coverage with a zero premium, and they would fit perfectly into that safe harbor. The other hurdle under this penalty is it has to be minimum value, which essentially means the plan pays at least 60% of the covered benefits. And you can do that by plan design. You can go to the government and enter in your deductibles, copays, coinsurance, and they will tell you whether or not your minimum value. And then if your plan design really doesn't fit neatly into the calculator, you can go see an actuary. Most traditional today plans, major medical plans, will pass minimum value. That won't be the issue. The issue will be the affordability. And then you may be asking yourself, this is a great amount of information, so how are these penalties? How is the government actually going to know whether a penalty is triggered? And that is the segue for Harry Atlas to talk about reporting.
Let me add this before Harry starts. We had the question about the 5% population that might not be offered coverage. This $3,000 penalty, the affordable minimum value penalty that Tora just described, will apply if a person falls within that 5% or 30% cohort in the special 2015 year, if that particular individual happens to go to the exchange and get the subsidy. So in addition to the affordable minimum value $3,000 penalty, also if you have someone that falls in that cohort that's not getting coverage that's permissible, if they still go get a subsidy through the exchange, there's a $3,000 penalty that applies to that.
So we're going to address one question before we go on to Harry. Someone from the webinar asked, if an employer offers affordable coverage to an employee and the employee declines and then goes to the exchange and receives a subsidy, how can the employer avoid the penalty? Can the employer ask the employee to sign a waiver since they gave up the coverage? Is that a way around the penalty?
So the penalty is only triggered if the employer failed to offer affordable minimum value coverage. So if the employer actually said it's affordable, it's minimum value, and the employee goes to the exchange, a penalty won't be triggered, and in fact it can't be triggered because the employee won't be eligible for a subsidy. To be eligible for a subsidy, It means that you don't have an offer from your employer of affordable minimum value coverage and you meet the income requirements.
Great. Thank you. And Harry is now going to talk about reporting of coverage to IRS and participants.
Yes, thank you, Lisa. So you've heard in great detail about what an employer needs to think about as far as structuring their offers of coverage, and Chris is going to talk about interactions with the exchange. My topic of reporting really bridges the gap between those. As an employer, there's going to be an obligation to aggregate and assemble and be able to document and support sufficient detailed information to demonstrate which employees were offered coverage and under what circumstances to allow for the administration. And so that's a conceptual overview of where this piece fits into the presentation. The reporting is going to be on a calendar year basis because employees, individual taxpayers are on a calendar year basis. The reporting is going to be on a calendar year basis regardless of your plan year. And the first year for which you're going to have to report is 2015. So your first reports will be due in early 2016. There are two overlapping sets of reporting requirements, and one of them I'm just going to mention very briefly now and then put to the side, and that is the reporting requirement under Section 6055 of the Internal Revenue Code. And that's the reporting requirement which is designed to enable the IRS to enforce the individual coverage mandate, the requirement that each individual have coverage. And that's a simpler report. The report that we're going to focus on today is the report that employers that are so-called large employers that are subject to the employer mandate have to file in order to enable the IRS to determine whether there are penalties due, and also to facilitate the exchanges and to allow the exchanges to know if an individual is eligible for a premium subsidy. To start with, because the reporting regime is intended to allow enforcement of the employer mandate, the defined terms and concepts that are used in the reporting requirements are the same as what you've just heard. So when the reporting requirements talk about a full-time employee, reporting information for a full-time employee, it means the full-time employee as determined based on the method that you use. So we need to think about that you'll need to be able to support who it is that you assert is and is not full-time. You'll have to have documentation to support that in order to support your reporting. And the basic, very, very big picture, the reporting regime is reminiscent of Form W-2. We're not talking about the W-2 reporting of the value of coverage. That's a different topic. But it's reminiscent of W-2 in that there's going to be, the employer is going to have to provide a report to each employee by employee, and then there's also going to be an aggregated data report on the employer level where the employer reports for all of its full-time employees on an aggregated basis. And each employing entity is responsible for reporting. So if you have a controlled group, each employing entity has to report for its employees. The IRS is going to issue forms. It's going to be the Form 1095-C, which is going to be the individual employee-by-employee form, and then there's going to be a Form 1094-C, which is going to be the aggregated employer-level form. And those have not yet been issued. A lot of this will become more clear once those are issued and we see the actual format and we also get the instructions, because in some places the regulations refer to the instructions to be issued. So there's still gaps in what we know about precisely how this is going to look. And one footnote is you heard about 100 is the new 50, at least for 2015. That does not apply for reporting. So if you're between 50 and 100 and you're exempt from the mandate for 15, you still have to pay attention and report. So that's kind of a disappointment to some employers. Let me start by talking about what we'll refer to as the primary method of reporting. conceptually, the IRS has laid out this general primary method, which is, as we'll go through, involves a voluminous amount of data. And then there's a couple of exceptions that, if you happen to be able to meet them, will allow you to provide truncated or abbreviated reporting. But the primary method of reporting, you're reporting for each full-time employee, employee by employee, month by month. So a lot of data points. And you're going to be reporting whether each individual and their dependents were offered minimum essential coverage. You're going to have to report the employee's premium cost share, and for the lowest self-only option. And also you have to report whether the employee accepted coverage. So all of the things that you heard about that go into the determination of whether a penalty is due, whether the coverage was affordable, was it offered to full-time, you're going to have to present data to the IRS to show that. So each employee, month by month, the total number of employees month by month, whether a waiting period applied to each particular employee month by month. Another aspect of the reporting is the controlled group. Because there is relevance to the controlled group, the report is, if you have a complex corporate structure, you're going to have to report to the IRS. Each reporting entity is going to have to list for the IRS all of its controlled group members, which for some employers, for many employers, there's not a big deal at all. They know exactly who they are. But for some employers, that's a very complicated question and one that they may not really fully know. So that's going to be embedded in the reporting requirements. There's also additional provisions that relate to governmental entities, where it's oftentimes not completely clear how the entities aggregate with each other, and there can be practices that have developed as allowing one entity to serve as a payroll for another entity. There's rules that go into that. And then, as I mentioned, there's this gaping hole of any other information required by the instructions to the forms that haven't been issued yet. So we still may see additional surprises when those forms come out. As far as the timing of the reporting, the report, if you file electronically, which most employers probably will, it's due by March 31st. If you file on paper, it's due a month earlier. So in addition to the report that goes to the IRS, each employee will get an individual statement, kind of like the W-2, different forms, Form 1095-C, and that statement will have the information for that individual employee and has to be provided by January 31st, the same time frame as the W-2. That's the basic structure. As I mentioned, there are a couple of alternative reporting methods that, if you qualify for them, can allow you to report less data. But if you think about it, you're still going to have to keep records because you're going to have to show that you qualify for these. So keep that in mind. This is not a free pass from data maintenance. But the concept here is that if you make these sort of offers, it's not necessary to get into the same level of detail with the IRS. The first concept is the concept of a qualifying offer. And the qualifying offer is one which is made to a full-time employee, to a particular full-time employee, for all months in the calendar year for which the individual was a full-time employee, except for example, during a waiting period. Coverage that provides minimum value, which, as Tora mentioned, should not be a problem for most major medical plans. But the real issue here is that it has to be affordable under the poverty level test. It has to be, you have to charge the employee so little for self-only coverage that it's completely evident from the offer itself that it's affordable. And the objective standard for that is the federal poverty level, which equates to $1,108.65 for the year. So if you have employee-only coverage at no cost or very little cost, you may qualify. Many employers simply will not qualify by virtue of that affordability constraint. And in addition, the offer has to extend to spouses to qualify for this exception. Now, you don't generally have to provide coverage to spouses to avoid the penalties, but for it to be a qualifying offer, you would have to make an offer to spouses.
And Harry and I have discussed this and wonder if this reduced reporting requirement is a way to drive policy a little bit more. So again, as you said, no requirement to offer spousal coverage, but if you want this special exception, you need to be offering it. So it's sort of a backdoor into having employers not drop spousal coverage.
Right, and offering some incentives that are beyond the letter of the law. If you have a qualifying offer, then there's going to be an abbreviated reporting form, and the qualifying offer is evaluated employee by employee. So you can have some part of your population for whom you make qualifying offers and you have abbreviated reporting, and others for whom you do not. Question?
Yeah. So if under the notion that you would make employees eligible for fewer hours than 30, let's say in order to make sure you don't run afoul of that 30-hour limit, you're letting people into your plan for 20 or 24 hours. They're low-paid employees. Would it be possible to trick yourself into a position where you're offering them something that's not affordable? It would encourage you then to give a higher subsidy to the premium for those lower-paid employees. Do you understand what I'm saying? In other words, you can't have them spend more than 9.5% of their income. Well, if they're working really 20 hours at a low-paid job, that may not, the premium that they would have to pay could very easily exceed that.
You're not going to trigger the penalty, though, unless they're working the 30 hours.
I was just about to say.
Okay, gotcha.
Because the penalty is triggered on if a full-time employee gets the subsidy, and that full-time is the 30-hour mark. So therefore, if you have that 24-hour, they wouldn't be considered that.
That's a good question. There's a special rule for 2015 only if you make qualifying offers to at least 95% of your full-time employees. There's going to be further relief from the amount of information that you have to report to the IRS. That's a one-time offer for 2015. And again, we don't have the forms yet, so we don't know exactly how that abbreviated reporting will look. And the second alternative reporting method is we can think of it as a 98% offer. And what this is really similar to what Tora alluded to. This is another little nudge in the direction of giving a little bit more than you're really required to under the letter of the law. If you make offers of coverage that provide penalty protection, so they're affordable, they're minimum value, and you make them to at least 98% of your employees instead of 95 or 70. If you make them to 98% of your employees, then you don't have to report on all that month-by-month data. But you do have to make sure that the report lists your full-time employees, so you'll have to keep the data. So this one may be attractive if you're in a position of planning to make an offer of coverage to 98% of your full-time employees, but it's not going to eliminate the need for data tracking. And finally, as far as what happens if you don't comply with the reporting, there's a potential penalty of $100 per late or incorrect return filed with the IRS per person, and $100 per late or incorrect participant statement per person. So potentially $200 per person for incorrect reporting. You can ask for a waiver of penalties if for a reasonable cause showing, but that's not a certainty that that'll be granted. So potentially significant penalties in their own right. And with that, I will turn it over to Chris to talk about the changes.
We have one question. If you make an offer of minimum essential coverage at the time of hire and it is declined by the employee, is there a need to make the offer each month thereafter, or is it enough to make the offer at each subsequent open enrollment or upon a life event trigger?
So there was a lot in that question. So generally speaking, if you have somebody that you need to make an offer of coverage to, you need to make it once at the beginning of the plan year, typically speaking. The caveat I would have is if you're using the monthly measurement method and you know somebody's going to have a spike in hours, so for some reason you're using monthly measurement and you know you have seasonal employees, you want to make sure you get an offer of coverage out before that month starts for that seasonal employee that you know is going to be averaging 30 hours or more a week for that month. Now, as far as nothing has,
You want me to give you the second part?
Yeah, what's the second part of that? Life events, yes. I mean, nothing has trumped life events in any of this either.
Okay.
So marriage, adoption, all of the HIPAA special enrollment rights still apply.
So it's not every month, it's not the next open enrollment. One of the factors is whether or not you know that someone is then going to have enough hours.
If you're using the monthly measurement method.
Mm-hmm. Okay. Chris is going to talk about the interaction of exchanges.
All right. And this was all a good segue into what I'm about to talk about, and then a good segue into what Todd's going to talk about, is the 6056 return that Harry just discussed really is intended to help the IRS and help the exchanges determine whether an employee is indeed eligible for a premium subsidy or not. That is, are they being offered coverage? Are they being offered, if they are offered coverage, is that plan affordable minimum value? That's important information for purposes of, again, determining whether someone is subject to the eligible for the subsidy, to which then the employer is subject to the penalty. So I'll take a step back to address what I just discussed, but to start by saying a lot of folks, especially if they're larger employers, especially if they're self-insured, are saying, hey, I really don't have to worry about the exchanges because the exchanges under the law are really only available to individuals that aren't getting insurance through their employer or small employers. Well, that's not quite the case because we now have the employer mandate. And as was discussed, the penalty under the employer mandate is only triggered if an employee, a full-time employee that is, goes to the exchange and gets the subsidy. So there is going to be some interaction between the employee and the exchange, and then the exchange and the employer in some circumstances to determine whether the employee who is trying to access that subsidy is indeed eligible because their plan is either unaffordable, doesn't provide minimum value, or they fall into that 5%, 30% cohort that I described. So going to my first slide here, it's information that we've discussed already, which is the general rule for being eligible for the subsidy is if you are offered a plan, i.e. an employer plan, you are not eligible for the subsidy. That's the general rule. But there's the exception to the rule that Tora described earlier, which is, but if the employee's plan, if that offer is not affordable or does not provide minimum value, well then that actually triggers eligibility to access the subsidy. But in order to access the subsidy, you have to purchase a plan through the exchange, and in addition, you have to be income eligible, as Tora described, between generally 133% of poverty and or really 100% of poverty and 400% of poverty. So there's a number of eligibility requirements for being able to access the subsidy in the first place. But again, going back to what's most important for employers is really the first trigger or the first eligibility point is your plan affordable? Is it provide minimum value? And if it's not, then again, you're eligible. So what happens if an employee goes to the exchange and says, hey, I believe that my plan is either unaffordable or does not provide minimum value, or I fall into that 5% or 10 or 30% cohort? Well, the exchange has to verify whether that employee is indeed telling the truth. And there are regulations that the Department of Health and Human Services issued that actually imposes a verification process or a requirement under which the exchanges must verify whether that employee is indeed, A, presenting to the exchange the necessary information or telling the truth, if you will, whether they're eligible or not. Well, going back to where I just started with my comments and what Harry spoke about, the 6056 return is intended to serve as that piece of information that the exchange can look to verify. But in the event the 6056 return is not available, the regulations that discuss this verification process require the exchange to look to literally an electronic data source. Well, sadly, we don't really know what an electronic data source is. You can speculate to say, well, maybe it will be a repository of information that employers are going to be able to give to an exchange that the exchange can hold, and whenever an employee of that employer goes to the exchange, they can then access that repository of electronic information. That's actually been suggested by folks in the industry. It hasn't yet been, let's say, put into regulations or put into practice. So again, we don't really know what electronic data source is. Well, there's a couple other steps that an exchange has to take to verify. One of the last steps being the exchange may even send a letter to the employer or call the employer up and say, you know, I'm an employee of Venable. Hey, Venable, Chris just came to me and said that your plan is unaffordable. He really couldn't provide me information justifying that claim. If you don't tell me otherwise, I'm going to have to give him the subsidy. And Venable at that point has the opportunity to, let's say, present the appropriate information to determine whether my plan was actually affordable, and therefore I'm no longer eligible for the subsidy. Well, let's say Venable doesn't do that. Again, the regulations say that the subsidy will be offered to me, that Venable employee. In that case, technically speaking, the penalty has been triggered, right? So I was the employee that got the penalty, and thus Venable, my employer, should be on the hook for a penalty. Let me take a step back to focus on, to an extent, what the enrollment periods are under the exchange. So I'm this Venable employee. When can I actually go to the exchange and say, hey, I am eligible for a subsidy because my plan is unaffordable to me, for example? Well, there's only certain times that you can do that. Under the exchange regulations, there is an open enrollment period during which a consumer, an individual, can go to the exchange and try to buy a plan on the exchange. The initial open enrollment period for this 2014, I'm sure everybody knows, it's been in the press, was October 1 to May 31. There are special enrollment periods in addition to the open enrollment period. And for example, one special enrollment period that was added during this initial open enrollment period was if you were in line or you had some IT difficulties, you had all the way until actually October 15th. And in some states or some jurisdictions like D.C., you had all the way until April 30th to actually enroll in an exchange plan. But this is all just to give you a sense of there's a certain time in which a person, just like in the group context, person can enroll. Well, within these special enrollment periods, there is also one that says if the employee happens to be eligible for a premium subsidy. For example, because their plan is unaffordable or doesn't provide minimum value, then that gives me the right to go to the exchange and access the subsidy. And then again, what I just talked about, the whole verification process, is then triggered. Maybe it's short-circuited because the 6056 return is there and thus is information that can be easily accessed. There might be instances where that's not the case. For example, in 2014, we obviously don't have the employer mandate penalty that is being enforced, but the premium subsidies are available. The 6056 returns aren't available. There are some situations now in 2014 where the federal exchange, so those states in which the federal government is running their exchange, this verification process is supposed to be followed. In truth, I've not heard of any employers that have been contacted by the federal exchange in those states where the federal exchange is operating, but it is a rule on the books. The verification process for state-based exchanges, like Maryland, like D.C., like others, actually regulations did delay this verification process for a year because this administration recognized the need for transition and the difficulty with complying due to the fact that the rules are not out. So at least if you're in Maryland or D.C., generally this verification process is not there, but it will be there in 15. So it's important for employers who don't think that they're going to ever interact with the exchange, may interact with the exchange as a result of the employer mandate. And I'll say one last statement and turn it over to Todd. So as I indicated, I gave you the scenario. I actually get the subsidy because Venable couldn't verify or the exchange couldn't verify whether I was telling the truth, whether my plan was affordable or not. Well, the penalty is then triggered. Well, the IRS sends a letter to Venable and says, hey, Chris just got a subsidy. That then starts an appeals process where there again is interaction between the employer and at least the IRS, maybe not so much the exchange. So with that, Todd, I'll turn it over unless there's a question.
Well, I wanted to interject for a moment. For the reasons of what Harry addressed and what Chris just addressed, I think employers that have fiscal year plans may find themselves migrating to a calendar year plan because all of that complicated reporting happens on a calendar year regardless of what your plan year is. And then I have seen employers with fiscal year plans that are just beginning now struggling a little bit that open enrollment has closed on the exchanges, that employees are saying, I want to be able to comparison shop. So I think for that reason, you may see more, if you're on a fiscal year plan, you may have a push to some point having a short plan year and then joining a January to December plan year. There's a question, Lisa, if you want to read it.
We had a question from a webinar participant. When are benefits effective if someone enrolls November 29th, for example? Is it the first of the month following or another date?
I would assume the question's relating to an exchange plan. It is the second month, so it's the first day of the second month. Let me take a step back to say the exchange reg said if you enroll between the 1st and the 15th of a month, the effective date will be the first day of the following month. But if you happen to enroll between the 15th of the month and the end of the month, let's just say 30th, then the effective date of that plan is the first day of the second month. So what we're in May, let's just say I enrolled May 1 through 15, well then my coverage is effective June 1. But if I enrolled May 27th, then my coverage is not going to be effective until July 1. That's how those rules work.
Great, thank you.
Hi, my name is Todd Horn. I'm somewhat of the oddball up here because I'm not a benefits attorney. I am an employment litigator. I represent clients in court when they're sued by employees and also work with my clients to try to keep them out of court in the first place. We're going to change gears and step away from this tidy, well-mannered structure of the Affordable Care Act and look at some of its more gruesome aspects, its hidden tripwires, if you will. And I'm going to try to point out to you some of these tripwires that really just haven't bubbled up to the surface and got the attention they deserve. So imagine, if you will, you have an employee who is not performing up to specs, and you put them on a performance improvement plan. The employee recognizes the writing may be on the wall, so they go to their manager and say, you know, I don't think this health plan you have is compliant with Obamacare. It's just not good enough. Walks away. Weeks drag on, performance doesn't improve. The employee is terminated because they haven't successfully finished the PIP. Do you have a problem? Well, we'll see, okay? Imagine, if you will, you have several employees who generally work about 35 hours a week. However, you decide you're going to cut their hours to 29, okay? Make them part-time because you don't want to go to the expense of having to offer them health care. Problem? We'll see. I'm going to discuss two laws in general that create risks for you all in dealing with these and other situations. The first one is the Fair Labor Standards Act. And I know what you're saying. I can hear you. You're saying, Todd, you're mad. The Fair Labor Standards Act is that Depression-era law that governs minimum wage and overtime, and it has nothing to do with health care, right? Well, you know, we're talking about hidden secrets. We're talking about tripwires. They're not supposed to be obvious risks. They're hidden, and this is a hidden one. Now, the FLSA was, in fact, amended by the Affordable Care Act to include very broad anti-retaliation provisions against your employees, very broad whistleblower provisions, and permit lawsuits with extraordinary expansive remedies. Do you guys want to see the law? Okay, I brought it with me. You ready? Brace yourselves. There it is. Yeah, for those of you on the web, I'm holding up a teeny piece of paper. It's microscopic compared to most laws. It's actually kind of cute, okay? But don't be lulled into a sense of security just because it's short and sweet. It is actually devious and dastardly, and we'll talk about some of its provisions. There are two general parts of the law that employers really need to focus on, and the main one is the whistleblower retaliation provisions. And those provisions have two parts. One part is defining protected activity, what an employee does to get protected, and the other part discusses what an employer cannot do in the face of protected activity. So let's go through some of the protected activity. There are three aspects of those. The first one, which you see up there, is called participation. If an employee is protected against retaliation because he or she has testified, assisted, or participated in a proceeding concerning an ACA violation. Okay, that generally means an investigation by the DOL. But look at that. It says, or is about to. That's not a typo. They don't even have to do it to get protection. They just have to look like they're doing it. They can do a head fake, and they're protected. Next, complaints. That's the second type of protected activity, and this is enormous. Okay, I'm not exaggerating. This provision here you're looking at, although it takes up a couple sentences, is the most expansive anti-retaliation provision in American law that has ever been written. Let's look at what it says. It prohibits a company from retaliating against an employee because he or she, look at this, has provided or is about to provide information to either the employer or the government about an act or omission that he or she reasonably believes violates the Affordable Care Act. Okay? Look at the breadth of this language and how much protection it gives employees. Virtually any employee can shroud themselves in protected activity. It covers both actual and potential complaints. Remember, they don't even have to complain as long as you think they're about to. It need not be in writing. And here's the amazing thing. It doesn't even have to be correct. They could have no idea what is in the Affordable Care Act, but they have a reasonable belief that your plan isn't compliant. That's enough for them to get protection. Third, another biggie is opposition. This prohibits retaliation because the employee is either objecting or refusing to participate in any act, task, or assignment that they, once again, reasonably believes violates the Affordable Care Act. And you heard from the previous hour just how many nuances and nooks and crannies there are. So if there's any objections that they make, they can be subject to protection. The second big aspect of it is what you all as employers cannot do in the face of employee protected activity. It's retaliation. Okay? The language is pretty broad. It's up here. Prevents an employer from discriminating in any manner against an employee with respect to his terms, conditions, privileges of employment. Now, what does that mean? How far does it go? Well, here's a list of some of the things that the Department of Labor has identified. From the top down, you can see a lot of more common sense, and we all know termination, demotion. But then they start getting a little nebulous. Negative performance evaluation, discipline. I mean, is coaching discipline? Who knows? Compensation, benefits. Then the bottom three are really vague, really subjective: blacklisting, denial of opportunities, threats, intimidation. So if you have an employee who complains your plan is not compliant, and then the boss doesn't allow them to go to a conference, do they have a whistleblowing action under the Affordable Care Act? Potentially so. These are very hard claims to defend against. Okay, and as I said, reasonable belief is enough. They don't have to have a real violation. Oh, and here's another thing. Let's say the employee is not motivated by a desire to help the plan, but they really want to punish their boss or protect themselves from termination. May not matter. Their motive for bringing the complaint is not necessarily relevant. Okay, the second big way in which, the second big tripwire I want to talk about is penalty avoidance. You heard this morning various details about the no coverage penalty and the unaffordability penalty that can fall in your footsteps. And some employers are thinking, well, gee, maybe if we arrange things differently, we can avoid these penalties. And some of them have some pretty easy solutions. I mean, you can reduce your head count so you're not a large employer, right? And that way you don't even have to provide coverage. Or you can reduce employees' work weeks or hours so that they are not full-time. Remember the second, imagine if you will. Or perhaps you want to convert some of your employees to independent contractors so they don't get entitlement to coverage, okay? Sound like common sense solution to avoid the penalties, right? Yes, sir.
Going back to my earlier question, do you think that in this category you include employers that, when looking at their appropriate entities, identify a few entities that might have more sensitivity to the 5% threshold, rearrange their corporate structure, be in compliance with the law, but as a result of that, give them more flexibility in one entity that didn't exist prior to that, that would fall into this risk category? Is that more neatly attached?
Well, I'm going to defer to the employee benefit folks when you talk about control group.
Excellent question. And time will tell. I'll repeat it. So he's wondering, that somebody in the audience, is whether we should have another bullet point on the slide that says rearrange the deck chairs of the corporate entities so that you can play with that 5%, 30%, and 2015 margin of error. And while you could technically do it under the tax provisions, do you fall short under this FSLA? And I think time will only tell. It does raise a little bit of concern given how great a job Todd has done in telling us how broad these provisions are.
They get worse. Here we go. Now, in addition to the Affordable Care Act, we also have to consider ERISA. You all live and breathe it, but you probably know that within ERISA is its own anti-retaliation provision, which prohibits employers from taking adverse action, termination, et cetera, because an employee has exercised their rights under ERISA, such as filing a claim for benefits. It also has a provision that prevents employers from taking adverse action against in order to interfere with future benefits, benefits to which they may become entitled to. So the theory is as follows. If you reduce hours of an employee with the specific intent to deprive them of participation under your plan, they may have a claim under Section 510 of ERISA because you have interfered with their rights to future attainment of penalties.
Todd, we have a question in the back.
Yes.
We are a private employer whose main client base is the federal government, so that in itself presents some issues of compliance and other issues that aren't even worth mentioning here. But we have categories of employees that are called temps. They work anywhere from 20 to 40 to 39 hours. They are short-term temps that work anywhere from 30 days up to maybe 4 or 5 months, because we have some limitations of how many hours a year they can work because of the state that we actually work out of. They're not employees. They don't get 401k. They're not entitled to retirement or any of that or the benefits. So we've got a temp category, then we have a part-time category of employees who work 20 to 39 hours who pay a higher premium of the employer. The employer portion is paid less to those people based on the number of hours they work. Now, going back to your issue of reducing the hours, We currently have people who work an average of 30 hours, but they're all temps. So we can reduce those hours to 29. They're not getting benefits now anyway. They're not qualifying for the retirement plan now anyway. But because of that 30-hour rule, they're considered full-time employees. So if we reduce them to 29, I don't understand how that would be skimming per se or violating the law, especially since they weren't employees in the beginning for that group. For the part-time group, we will have an issue because if we're forcing them to pay a higher premium based on the number of hours that they work under ACA, we would be discriminating. Am I correct? There's two questions.
Well, I will answer what I can because it actually tracks both of our issues. If, in fact, with regard to the category, they are not your employees because they're in through a temp agency, do I understand that?
April Brady walks in and she works for, she says she can do this work for you for the next 3 months. You hire her as a temp. I don't come through an agency. You're going to pay me directly. I'm not an independent contractor.
So you're common law employee.
Yeah.
That's your employee then.
There's a basic,
Well, I understand what you're saying, but we're not.
there's a fundamental
They're
issue.
an employee without benefits. They don't qualify for any of the benefits.
Yeah, that doesn't work so well under the Act. If you are the common law employer, meaning there's no agency involved, and even if there were an agency, the definition that's key here is who is the common law employer, who's controlling the day-to-day activities. And if that's you, then you are the employer and you have all of the liability associated with them.
So if we reduce the hours to 25, then they're not an employee of our company, right, based on the 30-hour rule?
They may not be full-time, but they're still your employee. And if they have variable hours, then you want to be looking at a look-back method to track their hours.
And on the common law employee issue, there is actually kind of a court standard, a court-fashioned rule that the Department of Labor and other federal agencies look to for purposes of determining whether you are indeed a common law employee, to which then the employer is considered the common law employer. So I would say you would even arguably need an analysis in that regard to determine whether your temps are a common law employee or not. If they are, let's say, going through the analysis, common law employee, for purposes of the employer mandate, they're your employee, so therefore you have to comply with the law. So if you were to reduce to 29, well, then to get around the employer mandate, let's say, then you might have an issue. Now, what I don't know is, when it comes to this definition of common law employee, it is clear for the employer mandate purposes. Is it the same definition that's tracked in the case of, let's say, ERISA 510? That's a question that I don't know. I would think so, yeah.
Yeah, the tests are often so similar at the fringes they don't even matter, okay? Because it's easy to be an employee, okay?
Do you want to address the issue of whether the 401k exclusion is appropriate because there's no reference to the number of hours these people might have worked?
Right. Well, I do think, given what Chris raised about determining whether or not those are your common law employees, depending on what your plan document says, I think you should evaluate the 401k issue. And I would say that it is an increasingly difficult situation to convince the IRS to exclude people, and there's some general rules with respect to how long you've had folks that are excluded for a variety of purposes can actually be kept out of your qualified retirement plan. So.
Well, in addition to those risks under ERISA, the Affordable Care Act has embedded within it a similar risk if you start tinkering with employee hours. It expressly prohibits retaliation against an employee in addition to those three things we talked about, participation, opposition, and complaints. It prohibits retaliation against employees who go to an exchange and receive a subsidy or tax credit to get insurance. OSHA has specifically stated that if you reduce an employee's hours in response to that, you have engaged in unlawful retaliation. So the real question becomes, and it's still an open issue, is what about reducing an employee's hours before he or she goes to an exchange and gets coverage and receives a penalty, or receives a subsidy? There are arguments both ways that make it either plausible or implausible, but you can see how that these are issues that are going to be confronting you. And that's, again, we're here to point out these tripwires and work for you ways to get around them. So whenever we're dealing with issues of tinkering with employee hours, make sure that these are considered. These various laws have enforcement proceedings in there. If you violate them, they can haul you into court. They have very low burdens of proof for the employees, very high burdens of proof for employers. Jury trials, and you know juries, they like employees and don't like you all. Sorry. And it's very broad remedies, a lot of damages, including attorney's fees. So there's a huge attractiveness to bring these types of suits. Lastly, before I turn it back over, some risk avoidance issues that you want to consider. You want to limit any argument that there was a specific intent to either deny benefits or retaliate against a person. Best practices come into play to document legitimate, uniform reasons for decisions, update your plan documents, handbooks, job descriptions concerning full-time, part-time status so that whenever you plug situations in, plug employees in, you've got documentary support. And the last bullet I really want to emphasize is manage what is said, manage the chatter, manage the internal and external communications regarding your benefit strategy and staffing decisions. You don't want to have folks going around saying, yeah, we're going to a heavy part-time workforce because we don't want to have to cover benefits. It'll kill you. Thank you.
Right. Well, Todd scared me. I don't know anyone else. I'm just an ERISA lawyer. So we have one question from the webinar. I'd like to run through quickly next steps that we want to leave you with, action items, if you will. Let's see. Is this the advance? Yeah, someone could click to the next slide, please. So the first is to determine whether or not to play or pay. As Tora went through all those specific rules, you need to go through the analysis and determine if there's any reason why you want to consider taking the risk and evaluating between the A and the B tax where that risk may be. Next is to determine the measurement period. It's necessary to demonstrate compliance to the government and audit, so you want to have some documentation. One way to do that in particular may be in your plan documentation, but at a minimum you should have something memorializing the measurement period that you've selected and demonstrating how you're accounting, whether it's month by month, look back period, etc. I will talk a little bit about government audit, so while we're talking about the measurement method, we know that the Department of Labor in letters that may not be audits yet is asking employers about what that measurement method is, and they're adding it at the end of actual audits and exams that are going on, even though the Affordable Care Act is relatively new, and it takes a while for things to generally percolate in the audit or exam space. We're seeing that happen, likely mostly because the department is trying to educate themselves, but you want to be in the position where you actually have that documentation that you can just hand over quickly versus us trying to put it together later, and look very responsive to the government, and that would help alleviate any issues you had in negotiating with them. The measurement period should also be documented in the event of the employee claim issues that Todd and Chris both talked about. We have a bullet with respect to plan documentation. In addition to the measurement period, there are a number of things related to the Affordable Care Act that need to be in your plan documents. Age 26 should probably be in your plan document now, but if you haven't dusted things off, now is the time going into the next open enrollment period to consider what Affordable Care Act provisions need to be listed in your document, both for communicating to participants, but for showing compliance with the federal government if they come knock on your door. Next is to establish a record-keeping system. Harry talked in detail about the reporting and the regulations. You see it's very tedious. If you're fortunate enough not to have to be responsible for income tax and other tax reporting, but now you're going to have to do this, I mean, it's a full-time job in and of itself. So you'll need to talk to your, hopefully, outside payroll provider. They can give you something turnkey to help you put this in place, but you have to measure people in order to tell your payroll provider what you're doing. We've seen various arrangements out there so far where various payroll providers are just starting to sign people up for these things, but I'd encourage you to talk to one of us if you're trying to decide what the right way to go. Ultimately, the liability, the government has been very clear, is on the employer. They could care less about who is doing your information reporting, and all of those contracts you sign have indemnifications, and you're going to pay for, any failures with respect to reporting. The next bullet is with respect to the fiscal plan year issue, which I think Tora has already covered. But as you're going into your next open enrollment periods, if you're a fiscal year employer plan for your plan, then you should definitely be talking, I think, to counsel about what makes sense. This is not a do-it-yourself alone, go on the DOL website and figure it out type of a thing, because I think that there's some complicated rules that we haven't even had the opportunity to go into depth in with respect to fiscal year employers today. Last, I would touch on government audit. I referenced a minute ago, the Department of Labor has been very aggressive and pretty vocal in terms of coming out and generally letting employers know what their objective is, officially saying that they intend to touch every plan in the country in the next 5 years, which is seemingly impossible. But what we're seeing are one actual audit program that the department has in place that's pretty aggressive, voluminous, 52 plus questions we've seen on the request that we've gotten for employers so far, and they want every compliance notice you put out. They want all these essentially reports you have to put together, and so if you haven't been doing that day to day, that's a burdensome project. And some of them are just letters, which the department is saying are not audits, but we know from the IRS's checklist project for 401k plans in the last year and from what the government has said publicly, if you don't respond to those nice letters, someone will come knock at your door with an audit. So we should treat them all the same, because the compliance or lack of compliance and the consequences therein are definitely something that should be dealt with up front. So I don't know if there's any questions from the audience. Go ahead.
I apologize. I was late getting here to cover this. I'm sorry.
Someone's going to run a microphone to you. Thank you. So our webinar attendees can hear.
In terms of what interns were called in the past, and they were somebody that was there to train, to watch a skill being done. They were not required for any deliverables or work product. Okay, most of my friends whose children have gotten out of college can't find a full-time job, so they're all interns at established companies around D.C., and they say they're interns and they don't get benefits, but they're working anywhere from 30 to 50 hours a week. And I can't figure out what happened to the definition of an intern. And in this concept, does that now become, you have to count them as an employee, even though you're calling them an intern and they're training, but they've been with you for 7 months and there's no end in sight?
Yeah, I've looked into this question. The final regulations actually speak specifically to interns. They say if you have an intern that is really sponsored from an educational organization, if they're not, if they're subsidized, let's say, by a federal program, that you don't have to count them as an employee for purposes of the employer mandate. But let's say it's just an intern that comes to you for the summer. And in that case, if you are paying them, then the normal counting an hour of service that Tora discussed early on actually applies, and therefore you have to count those hours for purposes of determining whether they are full-time under the employer mandate. If you don't happen to pay them, however, well then therefore you don't have to count their hours, that is, for purposes of the employer mandate, because the nuts and bolts rule of the employer mandate is for purpose of counting 1 hour of service, there happens to be compensation paid to that person. And in the intern context, it's are you paying them or are you not? Yeah, that's a good point.
Jim.
Wouldn't that problem be addressed if you used a one-year look-back period?
Exactly. So either you're going to, for 2015, say you're within your 30% margin of error, which is okay for the no coverage penalty. You're still, as Chris alluded to, at risk for the B penalty. That becomes more problematic in 2016 and going forward when that shrinks to 5%. But most likely you'd want to use a look-back measurement. But the only downside with that is then if they are paid on an hourly basis, you're subjecting your entire hourly workforce within that corporation to the look-back measurement method.
Right.
Hi. My question is in regards to if you're trying to establish affordability of your plan, and you're not using the poverty guidelines, but you're looking at your own, salary and wages that you provide in your organization. Is that based on is that the base salary? Does that include any overtime a person may? And I'm with the federal. I was there at one time. I'm with local government, city government, and of course we have, our title pay, a whole lot of different things like that. So I just like to know what you're including in that law.
That is an excellent question. If you're using the compensation, you're using the employee's compensation from your organization, and you're using the box 1, which has a trick in it because box 1 is after you've taken out the 401k and the 125. So it actually has a negative adverse impact on the employer when calculating affordability. And again, that's not really predictive. It's at the end of the year, are you within the parameters? So if you're talking about an hourly workforce, you might prefer the rate of pay, which allows you to be a little bit more predictive about it.
But if you're using the rate of pay method and they work overtime in weeks,
Doesn't
how
matter.
does that impact it?
If they're hourly, it's 9.5 times the rate of pay times 130 hours a month, regardless of how many hours they actually work. It's a formula. You just use it.
So I don't know if they cut us up. Do you have a comment, Chris?
Well, I was going to say, before you ask your next question, I think you had a webinar question.
Mm-hmm.
Early on to the waiver question, because I was going to just say, hey, wait for some of my comments on the verification. The way I would look at if an employer requires the employee to sign a waiver, let's say, hey, my plan is affordable, it provides minimum value, that really doesn't mean anything for purposes of whether that employee is eligible for the subsidy or not, but it is evidence that the employer can present to show that they were indeed providing an affordable minimum value plan and that employee was aware of it. So it really isn't, a silver bullet, but it is something that you can use in the event, let's say, an exchange wants to talk to you about whether your plan is affordable minimum value, or if the exchange happens to pay over the subsidy and the IRS starts knocking at your door, which then triggers an appeals process to which you can once again prove to the IRS that your plan was affordable minimum value, and that, again, waiver is simply evidence.
Right. That's great. We have 2 webinar questions. The first being, we are a government contractor and we have several employees who are working between 30 to 39 hours and currently do not receive benefits. Since we have a specific contract amount of money that we have to work with, we are lowering the number of hours of our current part-time employees and possibly hiring additional part-time employees. Will this be a problem? This is similar to something we were asked, but I know all of these seem to be questions that keep tripping people. They're stuck on the part-time, so.
Well, if you, under, for example, the ERISA 510, it has to the employee has to show that the interference, the hour reduction was with the specific intent to interfere with their rights, okay? If you have reasons for doing so, independent of that, government contract obligations, staffing needs, business starts drying up, you have a much better argument that there should be no liability because it wasn't driven by evil intent.
Great. Next is, from time to time, we hire full-time temporary contract attorneys to cover during a maternity leave or leave of absence for approximately 16 weeks. Since this person is on our payroll more than 90 days, do we have to offer medical benefits? Our regular employees are offered benefits effective the first day the first of the month following the 30 days of employment.
Interesting, and this goes back to the documentation issue. Tora described that there is what's called a variable hour employee, let's say on a new hire basis, but there's also a standard that the regs say if you believe that that person that you are hiring is going to work on average 30 hours a week, you have to treat them as full-time. That's part of the analysis. So if you hire somebody, know they're going to work 30 hours a week.
Even if only for 6 months or 3 months or whatever the period of time is.
Correct. But if you reasonably don't believe they're going to work 30 hours because you don't know, well, then you can treat them as variable. Well, what factors, what's this reasonable test that you have to take into account? The regs actually give you some indication of what are the factors for you to determine whether, that person should be treated as full-time or whether they should be treated as variable. And one of the factors is the seat that they're filling, did you treat that as full-time before? And there are a couple other factors that are just escaping my mind. But let's take this temp context. If historically you've always treated that seat as working, let's say, 39 hours a week, or even 30 to 39, well then, to me, you would be considered or that person would be considered full-time. And thus, if they work past the 90-day waiting period, the regs say you have to offer them coverage or potentially be subject to a penalty. So therefore, in that context, I would say you have to offer them coverage. And back to the questioner about temps, yes, I think you have to go through that common law employee analysis as we discussed, but let's say they're not there for 3 months. Let's say they're only there for 2.5 months. Well, you don't even have to then offer them coverage because you can have a 90-day waiting period, and if they don't get coverage within that 90 days, you're okay. And they could terminate before that 90-day period ends, to which then you have to offer them coverage. So there's ways to kind of deal with some of these situations, but you don't want to be purposeful, as Todd indicated, and I hope that described or helped that question a little bit and answered the webinar question.
Right. Not
Tora,
that,
is that?
No, I agree. And actually, it makes me think on that intern question, it depends a little bit too on are they being hired at full-time or is it seasonal? Can you treat them as seasonal even if hired full-time? Or are they just there for the summer?
Yeah, because you could then, if you treat them as variable, you can throw them into your measurement period. And as Tora said, and I've advised, you should have a 12-month period because that's a longer period of time over which to measure their hours. They may never end up being full-time, to which then you're required to offer them coverage or face a penalty. Even though you have to count, but you have to count them if you pay them.
Well, thank you. Before we sign off on the webinar, we understood that slides were sent out this morning, but apparently people didn't get them. So we'll resend those so all the webinar participants have them. Is it possible to send them to attendees that want something more than what we handed out today? Okay, so we'll do that too. Thank you all for attending. We'll be around for a few minutes if you have additional questions. They will print these questions.
So, Chris, does this mean that you have actually read all these regulations? You seem to have a remarkable grasp of the detail.
Sadly, and there's even some parts that I kind of just glossed over because I didn't have to read them.
Right.
Just as one example, there's some international issues, expat issues under the reg.
Right.
I've never had to deal with an expat issue, so
you know where to find it.
Time, yeah, exactly. Glossed over it because I didn't have to read it, but I know where it is if I need to read it.
Yeah, well, I got to tell you, you're sharp on those issues, and I love it. So.
I always hope you're right. I believe I'm right, or I wouldn't speak. But yeah, it's a matter of just taking time and reading the stuff. I mean, you know how it is.
Yeah, but this is a different world.
Yeah, no, it is. It's interesting. Sadly. But.
Yep. Well, keep us in business, right?
Yeah, exactly. I'll let you know if I get anything coming your way, and let us know if you need us.
Absolutely. We're having. I'm just going to be down here on Friday. We're having our group is really working to get our groups together, and we're having a benefit boot camp.
Yeah, that's right. And I gotta talk to Tor about what's involved there, because I've not been
Oh, well, I hope to see you.
privy to all this, so.
Well, that's true.
Yeah, it really is.
You're not making
Yeah.
it up.
Yeah. I don't blame them, but for not believing it, but sadly you have to believe it.
Not 20, 30. And so I'm trying to figure out, you know, if we're able to stay below 50, then we don't have to.
Yeah, we're gonna resend the slides, and then you want to make sure we can track
Can you print the Tor and I to do like the
the questions. Yeah, we can get that. I'll figure out how to get that chat.
I don't have to because before I know it, this project is never going to be eligible again, because I have to do it anyway. It's like,
I would suggest you have to keep doing it because, for example, under the employer mandate regs, it simply says in the preceding year, as you have 50 or more full-time equivalents on a calendar day, like on a day, like a normal business day. Yeah, it's crazy because there's other standards like because I just looked at the Medicare secondary payer rules. I just know this because I looked at it, but it's a good example. There's an exception for small employers where Medicare can be primary if you have a group health plan. But if you're above 20, the group health plan has to be primary and Medicare is secondary. Well, in order to be considered under 20 employees to then get this exception, you have to be 20 employees or fewer for like 20 calendar weeks. So there's an inartful way of saying there's a period of time over which to measure it in other rules under the law, but under the employer mandate, it appears to simply say on a business day in the calendar year. So. Oh, I see, okay. I see what you're saying.
You want more specific?
Yeah.
So I guess we could send an email.
Right.
To the email address.
And I do try to articulate this when I give presentations.
We're not going to take any more questions.
Think of whether you're subject to the mandate in the first place, i.e. the 50 full-time equivalents, in bucket one. So we have bucket one here. And then who you have to offer coverage to if you are subject to the employer mandate is bucket two, okay? The first bucket, to determine whether we're in it, there are certain rules that apply that don't apply to bucket two. The measurement period only applies to bucket two, doesn't apply to bucket one. So therefore, you don't have to worry about the measurement period. But for purposes of bucket one, you do have a look back to the preceding year, and you look at that average business day.